A very, very good morning to all of you. It is indeed my proud privilege to welcome all of you to this Professor P.K. Tripathi Memorial Lecture. It's a very solemn moment because of the fact that we are honoring and recognizing and appreciating the extraordinary contributions of one of India's leading constitutional law scholars, public law scholars, a remarkable individual who had made immense contributions to the evolution of public law in India. Professor P.K. Tripathi had a very distinguished career. He served as the Dean of the Faculty of Law, University of Delhi, with distinction. He had inspired multiple generations of legal scholars and researchers and law students. He also, at a time when legal scholarship was not something that was widely prevalent among Indian scholars, Professor P.K. Tripathi published in some of the world's leading journals, including from Columbia University, but also other journals from around the world. Professor P.K. Tripathi was very conscious of the fact that legal scholars, professors need to be working towards the advancement of law through rigorous scholarship and writings. In fact, at a time when we in our own university are exhorting our own colleagues to contribute to scholarship and research, Professor P.K. Tripathi belonged to that generation where not only what it was difficult, because this was a time when there were no computers, there was no internet, there was no technology, painstaking, first-hand writing and visiting libraries, spending hours and days and weeks and months and sometimes years of research leading to a publication was the time that Professor P.K. Tripathi did that research. His contributions were truly remarkable and truly transformative. And scholars have written about it, and I had the privilege to get a direct view of the work of Professor P.K. Tripathi through my teacher and mentor, Professor M.P. Singh. When I was in Campus Law Center, Faculty of Law, University of Delhi in the year 94, 97, I had the privilege to actually meet Professor P.K. Tripathi and had some interactions with him. But one of the things that some people know, but not many of them know, is that Professor P.K. Tripathi also had a very unique possible distinction, although it didn't happen. As some of you know, the Constitution of India had envisaged the possibility of a distinguished jurist to be appointed to the Supreme Court of India as a judge. Never before in the last 76 years of our evolution, we have had any academic ever been appointed to the Supreme Court of India. That provision of the Constitution of India was never used. But I believe, and there are many more people who can testify to the fact that if there was one individual ever considered in the history of India to possibly take up the position of the Supreme Court of India as a distinguished jurist category, which was never used, it was Professor P.K. Tripathi, although it never happened. Alas, we never had him in the Supreme Court. I also want to mention that over the years, his son and daughter-in-law, both of them have been very dear friends of the university. Professor P.K. Tripathi's son, Mr. Parag Tripathi, a distinguished lawyer himself, a graduate of Harvard Law School and Delhi University himself, has been a great source of inspiration for us here in this university. He had taken up an honorary adjunct professorship at Jindal Global Law School, taught several years of our students on a number of courses. His wife, Nilima Tripathi, who's also a distinguished lawyer and an arbitrator, she has been teaching regularly at our university, and I would like to pay respects and convey my deep sense of appreciation and gratitude to both Parag as well as Nilima for their contributions to legal education and research. Lastly, I'm very fortunate to welcome my dear friend, Professor Jayanth Krishnan, to OP Jindal Global University and Jindal Global Law School. Professor Jayanth Krishnan is a distinguished professor of law and also heads the Center on Legal Profession at Indiana University, Bloomington, at the Moyer School of Law. As some of you know, Indiana University is our oldest and the most important and influential partner in our endeavor. We established the first dual degree program under the LLB JD framework with Indiana. We've had a generation of Jindal students pursuing student exchange programs, dual degree programs, and other programs at Indiana University, Bloomington. Because of Professor Jayanth Krishnan's leadership and his far-sighted vision, we have been able to build these relationships. Over the last 15 years, the president of Indiana University, the provost of Indiana University, several deans of all the schools of Indiana University have visited our campus. We have collaborated, we've had joint conferences, joint publications, many research projects. Over 50 Indiana professors have come to our campus and lectured. The relationship has been deep and pervasive over the last 15 years. Jay himself is very special for us. I had the privilege to meet Jay long before the establishment of the university, way back in the year 2006, precisely on 11th, 12th, and 13th of August 2006, when the first foundational conference that resulted in the idea of building a global law school in India was promoted. Professor Jayanth Krishnan was with me when we did this conference on essentially the idea of law, justice, and institutions. That early conversation, and since then, the very evolution of the idea of the university, Professor Jayanth Krishnan has been a fellow traveler, a great source of personal inspiration, a true champion of the collaborations that we have built around the world. Not only Jay had supported us, but also ensured that many of our faculty members get the benefit of the relationship that we built with Indiana University. Two of our faculty members, Professor Kalyani Unkule and Professor Kagesh Gautam, both of them have been able to do their doctoral programs under a very special initiative that both O.P. Jindal Global University and Indiana University Bloomington did. And that resulted in both of them completing their doctorates, and the relationship got even more strengthened. Jay frequents India, but besides that, he has made immense contributions to at least 5 major areas of research. First, Jay is an ethnographer, a deep understanding of law and society. His contributions to law and society is second to none. Second, he is also a distinguished scholar and a researcher who works in the field of legal education, not just in India, but also around the world. His seminal article, published in the American Journal of Legal History, tracing the history and evolution of Indian legal education from the days of the Ford Foundation to the more recent development of establishment of national law schools, is one of the most outstanding articles ever written on the subject. Anybody who's interested in knowing the history of Indian legal education, I encourage you to read Jay's article published in the American Journal of Legal History. In addition to that, he also works in Africa as well as in the United States. The third aspect of Jay's work is to study the legal profession. He is one of the world's renowned authority focusing on the changing dimensions of legal profession and how it augurs for the evolution of law and legal institutions. The fourth aspect of Jay's work is to focus on the working of trial courts, especially the courts at the lower level in India. His extraordinary work, research work, ethnographic work, field work conducted across 3 states in India, in Gujarat, Maharashtra, and Himachal Pradesh, painstakingly working for years together, understanding the work of the district courts and carefully collating it and to come up with some of the most important findings for access to justice as well as rule of law has been truly remarkable. That article was published in the Harvard Human Rights Journal, again one of the most influential works, and that was of course funded by the Ford Foundation. And the last bit is Jay's work on the Dubai Financial Center, as well as to how Dubai has evolved as an international financial center and how a unique legal system has been able to be created under another legal regime, and what are its implications for the evolution of commercial contracts, business interests, as well as other trade and investment related decision making. That's another very interesting work of J. Krishnan. So here we have an extraordinary man who transcends across multiple areas of research, who is a prolific writer, a deep thinker, and also an inspiring teacher. We're very fortunate that he's with us as we welcome him to deliver the Professor P.K. Tripathi Memorial Lecture. Thank you very much.
Thank you, Raj sir, for both sharing your personal anecdotes as being a student of Professor Tripathi and also your personal experiences with our distinguished speaker, Professor Dr. Jayanth Krishnan. I now call upon Professor Dr. Nisha Nair to deliver the introductory remarks.
Thank you, Professor Sakshi Sharma. Good morning, everyone. Today, we have gathered here for the memorial lecture in the honor of Professor Pradyuman K. Tripathi, a celebrated constitutional law scholar who immensely contributed to revolutionizing Indian legal education. This is an opportune moment for us to explore the evolution of legal education, reflect on its current state, and envision the shape it may take in years to come. In the Indian context also, it is important to take cognizance of the tremendous transformation that legal education landscape has undergone since independence, from the establishment of the Indian Law Institute in 1956 to the enactment of the Advocate Acts of 1961, followed by legal curriculum reforms exercises at Delhi University, Aligarh Muslim University, Punjab University, and Banaras Hindu University in the late 1960s, which led to the transition from the 2-year Bachelors of Law to the 3-year model. Professor Pradyuman K. Tripathi, who was then serving as the Dean of the Faculty of Law, University of Delhi, played a leading role in bringing these reforms. Professor Tripathi left behind a legacy of pedagogical and curricular reform that strived towards inducing a vibrant culture of teaching and research aimed at shaping generations of lawyers and administrators. He was a proponent of the Langdalian case method, which he felt is the greatest single United States contribution to legal education. Another important milestone in the evolution of legal education in India was the report of the Committee for Reorganization of Legal Education at the University of Delhi, prepared by a committee headed by Justice P.B. Gajendra Gadkar in 1964, which for the first time referred to the idea of national law schools. The Bar Council of India took several steps to prepare the ground for the creation of national law schools, leading to the eventual establishment of the first National Law School of India University in Bangalore in the year 1986 under the leadership of Professor N.R. Madhav Menon, another trailblazer for legal education reform in India, leading to the launch of the 5-year integrated BA LLB programs currently prevalent. It is important to note here that these transformations that occurred in Indian legal education were not in aloofness, but fueled with the spirit of adopting the best practices followed in other parts of the world while responding to the uniqueness of Indian context. Legal education plays a pivotal role in shaping the legal profession and consequently the administration of justice in any society. While through its interlocution and interpretation, law tries to shape and respond to the idea of the kind of society we would like to live in, legal education undertakes the vital role of shaping the individuals who would play an instrumental role in leading these conversations. Foregrounding Professor Tripathi's thoughts on the importance of legal education, I quote, "In a democracy, the responsibility of the law, and in that measure of legal educator, assumes tremendous proportions because of the constant need for striking and maintaining a nice and none too easy balance between the claims of indispensable regulation and inviolable freedom. These ruminations of Professor Tripathi continues to hold given our country's rich history, diverse societal fabric, influence of global trends, and complex legal framework. Today, we have an opportunity to critically examine the strengths, challenges, and opportunities of legal education. By examining various socio-political and economic realities that influence it, we can identify avenues for improvement in curriculum, pedagogical approaches, and the incorporation of technological advancements. These considerations are essential as we seek to nurture a generation of legal professionals who are equipped to address the complexities of contemporary society through legal practice. The emphasis on interdisciplinary studies, clinical legal education, integration of emerging legal domains, legal internships, and the advancement of ethical and professional standards are central to attaining these aspirations. Equally important is our contemplation of the future. What we do in the present will shape our future. Are we moving in the right direction? As the society evolves and the global forces shape the nature of legal education and practice, are we doing enough? Like all of you, I am eager to hear our distinguished speaker, Professor Jayanth Krishnan, on the theme of legal education, past, present, and future. I look forward to the insights that will emerge from today's lecture. Thank you.
Thank you, Professor Nair. Thank you also for sort of setting the stage for Professor Krishnan to take over. I now call upon our distinguished speaker, Professor Jayanth Krishnan, to speak to the audience on the theme of legal education, past, present, and future.
Well, I just want to begin by first thanking Professor Sharma, Professor Nair, Professor Menkar, and my many friends here at JGU. No, actually, I prefer it down. That's okay. So I really want to say that it's a true pleasure to be here today and to see people like Steve Marks and Vespa Popovsky and Kalyana Inkale, and then of course my former student Young Chung is here too. And so it's a real honor. But I have to also really pay great homage to my one of my dearest friends in the world, and that's Raj Kumar, Professor Raj Kumar, really, to me, the visionary global leader when it comes to how higher educational institutions operate in today's world. Raj has been an incredible inspiration for me. And I would just say that for those of you in this room, to take note of what a wonderful person you have here as your Vice Chancellor. None of this could have been done without Raj and his incredible vision. I remember sitting with him at the India Habitat Center back in 2006. Steve was there with me and a few others. And at first we couldn't believe that this idea could ever actually come into existence. And then yet to see it happen is incredibly moving. And it's just a real tribute to you, Raj. So thank you so much. I also need to say that I'm deeply honored to give the Professor P.K. Tripathi lecture. I've written about Professor Tripathi. I've known his family for many years. And so this is maybe one of the highest honors I could have ever received in my career. And to be able to do it here in front of all of you, these brilliant students and faculty is, again, I'm very touched by it. And I'm hoping that we'll have some fun today because I'm going to try to shake things up a little bit and give a little bit of a provocative talk and hope to get some feedback. It's a project that I've been thinking about for a while. And so this is my real first attempt to present it publicly. But I want to start off by asking a question. And that is, are law schools doing enough to teach students about the pressing socio-political issues of the day? And so that's going to be the question I'm going to ask. And I'm going to talk about it for a moment from the U.S. context. So I view myself as having really 1 foot in India, a place that I love and a place that I've been here for many, many decades working. But what I would say is that, you know, my home jurisdiction is the United States. And so to go back to the question here, are law schools doing enough to teach students about the pressing socio-political issues of the day? I would say that in the US, which is frequently seen as the model for legal education around the world, the answer is, well, oftentimes I think unfortunately not. And here I think we have to go back to the notion, and this is a question that I really want to be focusing on, which is how are lawyers and law schools governed today? Well, in a place like the United States, and I would say in India, I had a really nice discussion with a couple students before the lecture here. The legal profession is pretty much self-regulating. And that means that lawyers set their own rules of admission, ongoing practice, and who gets suspended. And this self-regulation is designed to permit those with the most knowledge, lawyers, to regulate their own specialized practice towards the ends of client services and towards protecting the public interest. But it also means that lawyers can set up the rules to protect their own interests. And the choices about market regulation, I would say, profoundly affect who has access to legal services and how good those services are. And so let me start with what we know, which is that there is a crisis in access to lawyers that has been deep and long-standing. And unfortunately, I would say that there's a mismatch. There's a mismatch between supply and demand through the income distribution scale. And here is where we tend to see the needs of higher income clients being generally met. And it's well documented that many people in the middle and the lower end of the income scale continue to struggle to gain access to lawyers. And this is what's oftentimes known in the literature as the justice gap. And the key question to frame this discussion is, what is the bar's role in creating this access problem? And what should be done to remedy it? And so that's going to be the focus of the first part of this talk. And that then leads to 2 questions. How well is our teaching in law schools preparing you as students to go and serve the public good? And then the second question, and this is something that Raj and I talked about actually just last night, how does the financial structure of law schools affect who comes to law school and what they do afterwards? Well, as it turns out, law school, in the way we think about it today, is really a 20th century phenomenon. During the late 19th century, apprenticeships, they were the primary means of becoming a lawyer. So to become a lawyer, and you can see this from the scale here, you had to get another lawyer to accept you on, which severely limited who could enter into the field. In the US, there were only a handful of university-based law schools, with a number of independent day and night schools. And around the turn of the century, the number of law schools started to grow rapidly. Much of the growth occurred outside of universities, with the proliferation of independent, full-time, and part-time schools, as well as short course schools that primarily catered to non-elite groups, often immigrants or the children of immigrants from Southern and Eastern Europe, religious groups, religious minority groups who came to the US around the turn of the century. And the explosion of law schools, and you can see this from the chart here, and the expansion of entry led to 2 trends during the 20th century that shaped the course of legal education, which is, again, shown by this slide. efforts by the American Bar Association and the states to basically try and upgrade the standards of legal education. And there was a convergence around the case method, the method that Professor P.K. Tripathi adored. And so I'm going to ask you, how many of you know who this person is? Does anybody know who this is? So this man is Christopher Columbus Langdell. Now, love him or hate him, he is responsible for how the majority of law schools, not just in the US, but in many parts of the world, function. Christopher Columbus Langdell was the dean of Harvard Law School from 1870 to 1895. And during his tenure as dean, law school teaching was revolutionized. What you see here is you had the case method being being promoted. You had the Socratic dialogue. You had a 3-year postgraduate training degree. And the idea here was to hone analysis through the Socratic method, to require sharp justification for conclusions, to enhance public speaking. So for those who were very shy, the point was to make them stand up in class for up to an hour just engaging with the teacher. Now today, many of us, including myself, practice what we call the soft Socratic method. Frankly, we don't want a revolution among our students. So we worry that if we were to practice the Langdellian method, that would get many of us in trouble. I myself remember being petrified as a law student, being asked by my law school professor, John Quigley, to focus on what the Eighth Amendment of the US Constitution was about. And for somebody who loves watching television shows like Law and Order, and at that time LA Law, of course I knew what it was about. The Eighth Amendment involved that there be no cruel and unusual punishment given to criminal defendants. And so I stood up, Professor Quigley called on me, and I froze. I didn't move. I couldn't speak. And he kept coming at me. He was a very nice gentleman, but he kept coming at me. And it was an intense experience, and one that to this day, I'm not sure was the most effective means of pedagogy, but it was one that Christopher Columbus Langdell really valued as being key to educating law students. And then what ends up happening? Well, in the 1970s and into the 1980s, you started to get a debate as to whether or not legal education was doing its work for the students who were in the classroom. And so these two gentlemen here on the screen, one was Anthony Kronman, who's the former dean of Yale Law School, who really valued and thought that the Socratic method was something extremely important for students to know about. And then on the other hand, you had in the 1980s, the birth of the critical legal studies movement. It actually dates back to the 1970s as well. And one of the pivotal players in this was a man named Duncan Kennedy, who really trashed the Socratic method. And he really trashed how law schools were functioning in the United States. According to Duncan Kennedy, the idea was that law schools were reproducing hierarchies. And the idea of the Socratic method only accentuated the power imbalance between the very strong professor and the student who was vulnerable and sought to learn. And so this was the ongoing debate. And so what you see in the 1970s and in the 1980s was this idea that maybe the Socratic method was not the best approach for teaching our law students. So with that said, we've talked about whether teaching in law schools prepares you to be a good lawyer who will serve the public good. I think the second question that we have to ask ourselves is, how does the financial structure of law schools affect who comes to law school? And of course, this is a major issue in legal education today, and it's one that saddles many students for decades, potentially, because of the debt that they have to carry. I was mentioning in the earlier session, maybe some of you were in that, I myself, I'm 53 years old right now, but I carried law school debt with me until I was in my late 30s. And it impacted me. It impacted the fact that it was very difficult to buy a home. It was hard to get a mortgage. It was hard to buy a car. And so the idea that law school debt could stay with a student for decades truly has a debilitating effect, not just in the early years after they graduate, but for potentially decades following. Okay, so then I would say what we have to do is we have to move from what happens in law schools to what happens in terms of students being able to be admitted to the bar. And of course, the question here is who gets to practice law? Now, like in the United States, I know in India there is a bar examination. Now, the bar examination in India is a little bit different because, of course, there can be many lawyers who never take the bar exam, mainly because they're practicing purely corporate, purely transactional work, and because they never have to go to court. In the US, of course, that's not the situation. Any lawyer, regardless of what area they're practicing in, has to take the bar. And here, that has also come into quite a bit of debate. I mean, you have people who have advocated for the bar exam saying, well, you know, the bar exam is actually a good thing. It promotes egalitarianism. It abandons the idea of connections and advantages for some over others. It levels the playing field. Of course, the sort of anti-bar exam people have started to ask quite a bit lately whether it's necessary at all. Does it really matter that you can score well on a particular bar exam in terms of what it means to be a good lawyer? Why shouldn't law schools do a better job in terms of flunking people out so that you don't leave it up to an exam at the end of the situation to determine who can practice and who cannot? A second question comes in, and I know this is also existing in the Indian context, and that's the moral fitness determination. If the exam, the bar exam, is problematic because of the impact of its purported objectivity, the moral fitness component of admission into the bar is the obverse. It raises concerns because of the subjectivity of its application across different cases. What does having good moral character actually mean? Well, a standard definition in the United States, but one that actually has been exported abroad, is that good moral character includes but is not limited to qualities of honesty, fairness, candor, trustworthiness, observance of fiduciary responsibility, respect for and obedience to the law, and a respect for the rights of others in the judicial process. But here again, whether we should actually have a moral and character fitness requirement is something that has come up for debate. So there are explicit reasons for having it, which is that it can protect clients, it can protect the reputation of the bar, but there are some other limitations to it. Might it not limit membership? Might it not protect the market in favor of a monopoly? And so what we have is an outline of our classic method of educating our students and admitting them to the bar. But has that been enough? Has that been what we really should be focusing on when it comes to legal education in our law schools? And so here I want to reiterate my argument and to say that in the US, at least in the US, the answer appears to be, I would argue, no. And this is what I want to say, which is that I'm not so sure that American law schools at this moment, and I would ask you about your own environment, but I will right now stick to my own home jurisdiction, whether law schools are doing enough. So let's consider, for example, the number one issue for US voters for today. And this just came out from about 10, 15 days ago. It's from the Gallup poll, the opinion poll, which is what issue is the most concerning for American voters today? And it turns out that immigration surges to the most important problem in terms of this list. So immigration is more important than crime. It's more important than climate change. It's more important than employment. It's more important than socioeconomic disparities. American voters have pinpointed that immigration is the key socio-political issue of the day. And why is this actually important for us to talk about? Well, we know that on November 5th, 2024, we have a presidential election. And both candidates are talking about this. So look at some of the quotes from the current president, Joe Biden, who says, "I want, quote, the toughest and fairest set of reforms to secure the border we've ever had in our country." And I don't know if you can see that there at the bottom. He says, "If given that authority, I would use it the day I sign the bill into law." This is President Biden. Now, of course, Donald Trump, we shouldn't be surprised, right? What does Donald Trump say? Well, migrants at the border are poisoning the blood of our country. And when he says, when he was president, under our leadership, when he was president, you were safer. Your family was safer. Your communities were safer. Your children were safer. Your borders were safer. And your whole country was safer. A lot safer. But does the US really have a border crisis problem? Maybe yes, but maybe no. I mean, the problem of migrants at the border, migrants have been coming to the United States at the border for decades. And actually, it's an open debate. So even though both Joe Biden and Donald Trump agree, or at least seem to be pandering to the American voter, I think it's actually an open debate. But what is not a debate is that the US immigration judicial system, that's where there is a crisis. And I would argue that both political parties are to blame. And that the calamity is that very few Americans know why, including law students in the United States. And so what I'm going to do here is just spend a minute giving you a primer of what the situation is like. So in the United States, the Constitution has three key articles that separate powers between the branches. Article 1 falls under the congressional powers, where there's legislative, that defines what the legislative powers are. Article 2 is the executive branch of government, where the US president sits at the top. And then Article 3 involves the federal judiciary. Now, Article 2 has 15 cabinet departments, plus there are federal agencies. One of these departments is the Department of Justice, that's headed up by the Attorney General, who reports to the president. So just look at this for a moment. The executive branch, under the executive branch, you have the Department of Justice. The president picks the Attorney General. He's one of the members, Merrick Garland right now, who is part of the president's cabinet. Now, here's something that very few people, including American law students, know, which is that for immigration, the number one issue for voters, according to the Gallup poll, the immigration courts in the United States don't sit under Article 3. They don't sit with the judicial branch of government. Actually, the immigration courts sit under the president's authority, under the Department of Justice's authority, and so that you have first-level immigration courts, 69 of which are spread across the US. There are about 700 immigration judges. You have an appellate body within the Justice Department that hears these cases. And then, of course, you do have the opportunity to get to the federal courts after you go through the Board of Immigration Appeals, but that's very difficult. And then to get to the Supreme Court, that's even more difficult, because the Supreme Court of the United States only hears about 70 cases a year. Think about that compared to the Indian Supreme Court, which can hear 70 cases in 2 days. So it is very hard if you're an immigrant and you're trying to get justice in the United States to get out of the executive branch Article 2 courts and into the Article 3 courts. Very, very difficult. So essentially, we have a major set of problems. The immigration courts in the US are inherently political. The judges in the immigration courts they answer to political appointees. Many people don't know this, but immigration judges can be sacked. They can be fired for issuing judgments that the Attorney General doesn't like, that the President doesn't like. So there's no judicial independence with the US immigration courts. Immigrants don't have an automatic right to counsel, even though immigrants can be detained for months and months and months. They can go to court and they're not provided with government-appointed lawyers. The prosecutors and the judges in the immigration context actually belong to the same branch of government. So you have the prosecutors who work for the president. You have the judges who work for the president. And the backlog is immense. This is something that Indians can relate to, which is that the backlog in the immigration courts right now stands at 3 million cases, with delays being routine. Now, sadly, the information on immigration courts in the US is not widely known. Not even in the place where this information should be known. And that's in US law schools. And so the question is, why? Well, let's go through the reasons. Administrative law, for those of you who are law students here, that's offered here, right? Is it a required course? It's a required, in the United States, there are 200 law schools. Only about 50 law schools out of the 200 require administrative law. The rest don't. My law school doesn't require it. Administrative law is not even on the bar exam for most states in the US. So law students don't get an opportunity to learn about the mishmash of immigration courts in the US. Relatively few US law schools have full-time faculty teaching immigration. I teach immigration full-time. It's my area of research, one of my areas, but that's not the norm. Immigration laws are extremely outdated. In the US, we're still using a law that was passed in the early 1950s as our main immigration law. In the US, there's only one law review publication dedicated to immigration. It's called the Georgetown Immigration Law Journal. Many, many law schools don't have immigration clinics. And very few law schools have vibrant student organizations that are focused on immigration. And so I would argue that this is the real crisis, not the crisis supposedly that's occurring at the US-Mexico border. Yet this conversation is not part of the general public discourse. And for that reason, I think it's really appropriate that we talk about this today at the P.K. Tripathi lecture. Because what P.K. Tripathi often in his writings implored people to think about was how law is being used in terms of today's socio-political discourse. And unfortunately, in the US, there is a deep chasm, there's a deep divide. And I would say that there are significant consequences, because what ends up happening is that there is a lack of informed debate currently in immigration, in the immigration space. So you have politicians, you have policymakers, many of whom themselves are lawyers, but have no background because they haven't been taught this information. And so what ends up happening is they go into the public debate completely unaware of what the situation is, and they're responsible for making policy. They lack a basic understanding of immigration law. Immigration is one of several crucial social policy areas that I would say remain underaddressed by law schools. That would include climate justice. That would include medical insurance. That would include providing health care for every American. That would include the homeless situation, the disparities between the haves and the have-nots. These are not social policy issues that our law schools are focusing on when they're teaching our students. Now, we can have a conversation about whether the law school is the appropriate venue. And I'm actually interested in hearing what some of you have to say about that, because I know that many people in my home jurisdiction would push back and say, that's not what law schools are supposed to be doing. I think that that's not actually the right approach. And so what I would say here is that legal education, in conclusion, is at a critical juncture. The foundation for what law students learn is vital for helping to solve our most vital issues. But the bottom line is that law schools, I would argue, need to do more. Otherwise, the consequences for politics and society are, I would say, perilous, if not outright bleak. Thank you.
I now call upon Professor Dhwani Melkar to deliver the concluding remarks.
Thank you, Professor Sharma. That was indeed a riveting session, Dr. Krishnan. Thank you so much. We are grateful to you for this long-standing association with us at JGLS. Thank you for sparing time from your extremely busy schedule to address our students, our young legal minds present here on such a pertinent topic, and I'm sure it did lead all of us to think about some plethora of fundamental questions revolving around legal education. Your session was a powerful testimony to the predominant role that legal education plays in shaping the thought processes of young law aspirants. When Professor P.K. Tripathi took up the task of pioneering leadership of modernization of Indian legal education, the landscape in India was primarily really bleak. However, it is the order of the day today that institutions across the country and the globe need to strive to develop a research culture and adopt innovative pedagogical techniques which train law students to imbibe a curiosity-driven approach towards pressing socio-economic and political issues. This paradigm shift would be a welcome change and is in fact manifested in the ideologies that JGU has adopted and time and again advocated by our Vice Chancellor, Professor C. Rajkumar. We are grateful to you, sir, for always motivating students and faculty alike to orient themselves towards focused research goals in order to excel in their legal career and their prospects. I'd like to also thank Professor Patnaik and Professor S.G. Srijit, who are unfortunately not present here, but it is due to their support and guidance that this particular session was made possible. My gratitude to Professor Dr. Nisha Nair for her pertinent remarks which set the stage for today's session. I'd also like to thank a team of faculty members, Professor Manya Pundir, Professor Sakshi Sharma, Professor Idrish Muhammad, all the supporting staff at the Vice Chancellor's office, Ms. Neha Gupta, Ms. Jyoti Satlani, Mr. Achintya, the supporting staff at the Executive Office, and all the members of the JG Events team to make this possible.